Thank you, Trustee. That's a very quick review. The committee members all have written summaries of what she just presented. And the agenda says we're going to have comments at the end, but I'm going to open it up for questions or comments on this particular section we've already heard. Representative Starnes.
And I'll address this to staff, please. But we hear of legislation that's being passed in other states to address the problem of illegal immigration. My question is, how much latitude do the states actually have when it comes to immigration policy? What is dictated by the federal government and what restricts our ability to pass statewide immigration law?
The short answer to that is we don't know, because a lot of these issues are still being litigated at all levels of courts in different states and federal courts. A lot of the stuff that you just heard Drummond talk about is subject to a lot of that litigation. So the main issue that you run into is that the federal government's power over immigration is supreme. So the question really becomes, a lot of these measures touch on immigration, but they aren't immigration regulations per se, and a lot of litigation turns on where that line is drawn. So I know that's not the most satisfying answer, but it is the best one.
Just to follow up, we just, as Ben said, we don't know. The Supreme Court has not ruled definitively on these issues in farms. E-Verify is the only one that they've issued definitively on. So, as you probably have heard, immigration legislation passed in Alabama is now working its way through federal courts. There have been some injunctions that have been granted by
Follow up, Representative Starnes.
Yes, thank you. Well, then, obviously, we want to spend our time being constructive and dealing with issues that we're able to deal with, not things that are outside of our purview. Of all these different bills that have been filed that are pending, have they passed in other states that are now being litigated? Or are you aware of similar bills that are being litigated, maybe farther down the track than where we have?
Someone on staff have that answer?
If the question is, are they being litigated? Is that the question?
Well, we've got a number of bills that are pending, that's passed one house or the other. And so my question is, were they signed in, were bills similar to these signed into law in other states are now being litigated?
I guess we can.
Just briefly, in the pending ones, there's some of them that I think there probably is no question there within the authority of the state to do. The two related to education, the prohibiting from attending community colleges or public universities, education pretty much is the state's domain. There doesn't seem to be any serious question regarding that. The distinguishing mark on driver's license of limited duration, again, that would be something states could do. The ones that probably are likely to run into litigation are similar to the Arizona and Arkansas ones is House Bill 343 and Senate Bill 604. Elements of those have definitely been familiar to the court. So those are probably the ones that are less clear as to where the state versus the federal bill is drawn. Same thing with Senate Bill 179 as to the carrying an alien registration document. So those are the ones that I think it's more likely you're going to have litigation issues.
I apologize.
Follow up.
You're going to have to jog my memory. The numbers are sort of vague to me.
I'm sorry.
Just tell me the basic substance of the bills you referenced.
The ones that from your purchase, the Arizona Style Comprehensive, that talk about things like criminalizing failure to carry alien registration documents, making it unlawful to employ unauthorized aliens, creating an elaborate enforcement scheme, things of those natures. The kind of things that you see in the Arizona and Arkansas laws, Alabama laws, are the ones that seem to be working their way through the court system. They've been challenged, there's injunctions, and they're in the midst of litigation at the circuit court level, and some cases in the Court of Appeals level in other states.
Okay, Dan, you had a follow-up answer?
Yes, sir. Another thing that's worth noting is that a lot of the times these bills are, strange things happen in them. Just a few days ago, the Alabama Attorney General wrote to the legislature recommending that some of these things in their bill, which is not discussed here, be repealed. And then in other cases, a bill that is very similar to Senate Bill 205 is still on the books in Arizona, but their Attorney General had to issue some guidance to make it consistent with federal rules. So a lot of the time, even when these issues are not being litigated per se, they are being tweaked in sort of non-normal ways by other parties.
Okay, Representative Cleveland?
For clarity, on the E-Verify, the Supreme Court ruled states were well within their purview requiring anyone to hire somebody to E-Verify.
Okay, further questions from the committee? Representative Starnes?
Certainly, I don't want to monopolize the conversation.
Go ahead.
Several years ago, there was a gentleman in Caldwell County, my district, has a hosiery mill, and he began hiring a large number of Hispanics. And he said it didn't matter if they were 18 years old or 60 years old, when they would come in, they would all claim when they would fill out their withholding statements, large number of dependents. And he said the effect was there were no tax deductions. And so then he said, basically the state was withholding no tax, and then they would leave before the end of the year, so he was sure that they were not filing income tax. Have we, or has the Department of Revenue established rules regarding the way the number of deductions that are allowed for anybody? Are there limitations to that?
We can certainly find out for you.
I think that would be, if that practice is common and it's occurring, then it needs to be looked into, because if someone is employed in the state, we at least need to withhold the proper amount of tax to make sure that we're collecting something.
I believe that's an answer. Will come back to the staff from the Department of Revenue. Correct? Okay. Of course, I've always been told that election documents, if you rely on election documents, you're committing a felony, but I guess it's the same thing on IRS documents. But if someone wants to commit a felony, it would be another issue, I suppose. Okay, further questions and comments? Representative Stevens.
Oh, yeah, sort of in Representative Starnes' vein, that it might be helpful for the committee at some point to say, here's some litigation in Arizona and Alabama that has not been challenged in any way versus here's things that are pending in litigation, so that we don't have to duplicate it.
Good comment. I hope to get into best practices in other states at the next few meetings, and staff will help us with that. Representative Pierce.
Let me ask you a question, as staff. Senate Bill 179, just help me understand it. It says making misdemeanor to violate federal laws. How you have the power to double impose it on federal law to make it a, can you help me understand that, please?
Well, there are federal, I'm sorry, Mr. Chairman.
Go ahead.
There are federal laws that require the completion of carrying alien registration documents.
Yes, sir.
And what Senate Bill 179 would do is essentially make it a state offense to fail to comply with those federal laws. So it's not creating any new substantive requirements. It's just saying if you violate the federal law, you are also violating state law.
I'm not a
Do
lawyer.
you have a follow-up?
Yes, follow, please. Is that double jeopardy? I mean, you violate federal law. I mean, just help me understand it. I'm just saying you get double something.
Yeah.
Those provisions, as far as I know, when they've been challenged, have been either enjoined or struck down every time. So the short answer to your question is, I think there are issues with them. I'm not aware that they've been definitively resolved at the Supreme Court level, but there was a case from the 40s that dealt with state-imposed alien registration regimes. And since that time, in addition to that case, you've got a lot of federal preemption case law as well as federal statutes. And so I think that explains why courts have maybe put the brakes on that sort of thing now.
Thank you, Mr. Chairman.
Thank you. Any further questions from the committee or comments at this time on what we just heard? President Fairclough.
Thank you, Mr. Chairman. Question for staff with regard to carrying alien registration documents that being in violation of federal law or requirement of federal law. What is the standing of a state or local law enforcement to enforce that federal law?
Anybody want to answer that?
As a general matter, and perhaps the sheriff can answer this better than I can, but my understanding is that it is agreed upon by everyone that local law enforcement officials can enforce criminal provisions of federal legislation. I think there's a little bit more uncertainty, or at least there was when I looked at this a few years ago, as to whether or not they can enforce civil laws. But if these are criminal violations, then if a local law enforcement officer became aware of the violation, he or she would be able to do something about it. That's my understanding.
Follow up.
Assuming that's the case, it has been a policy decision by the local government or the local law enforcement agency as to whether or not they do that. It doesn't require any kind of state authorization.
You know, I'm really not sure that we can answer that. As to whether or not there's an alleged criminal violation, whether to do anything about it, I think we'd have to defer to law enforcement.
Chairman, they may cover it.
Okay, let's, at the end of one of their presentations, possibly. The next on our agenda is review of, the overview of the 287G program and its implementation in North Carolina. I believe Sheriff Johnson of Alamance County.
Thank you very much, committee. It's an honor to be here today, and hopefully I'll be able to answer some of your questions, and maybe down the way you may be able to answer some of mine. I'd like to get started. Alamance County was the second 287G program in the state of North Carolina. The first was Mecklenburg County. Currently, we have 6 287G programs in the state. Wake County, Cabarrus County, Buncombe County, Mecklenburg County, Henderson County, and Alamance County. And I'll soon be in law enforcement for 40 years. And I would like to say that this is probably, to me, one of the most important tools that we were allowed to get and participate in order to protect our citizens in the state of North Carolina and Alamance County. Now, a lot of people have said a lot of things about the 287G program. We are a detention model program, which means the criminals self-identify themselves by committing a violation of law in the state of North Carolina in order to come through the jail doors. Once they come through and they're foreign born, of course, they are processed to see if they are in the country legally or illegally and who they really are. And that's what really concerns our sheriffs. We need to know who is in our jails. And I would say that probably somewhere around 80% that are brought into our jails that are here illegally give a different name, and we don't find out until they're put on our fingerprint ident system and find out who they really are and the number of encounters that they've had with customs or law enforcement. So what I'd like to do is give you a little history